The courtroom went quiet as Judge Stephen Breyer leaned forward. Everyone stared at Jasmine Crockett, a 43-year-old Congresswoman, as she stood confidently at the podium. What started as a normal discussion about voting rights was about to turn into something big that no one saw coming. Congresswoman Crockett, Judge Breyer said, his voice filling the silent room. In my 27 years as a judge, I've never heard an argument so clear and well supported. The other judges straightened up. Lawyers exchanged surprised glances. The audience started to whisper. No one could remember a time when a judge had publicly praised someone during a hearing, especially someone arguing their first case before the court. But what Crockett said next didn't just acknowledge the praise. It changed the whole course of the hearing and left Judge Breyer speechless for the first time in his career. Before I tell you what happened next in this amazing courtroom showdown, hit that subscribe button and turn on notifications. You won't want to miss our coverage of the events that are changing U.S. law and government right before our eyes. The courthouse hallways were busy that morning. Legal aides hurried around with case summary. Reporters gathered in corners, guessing what would happen that day. Security officers directed the growing line of people who wanted to watch the important hearing on voting rights that had captured the nation's attention. Johnson against the Texas Ballot Authority was a case about a Texas voting rule that cut over 300 voting locations, mostly in areas where people don't have much of a voice. A conservative court had backed the rule, so legal experts didn't think the challenge to the Supreme Court had much of a shot. What made this case odd was who was arguing it. State Rep. Jasmine Crockett, who represents Texas's 30th district, got permission to argue the case herself. Before becoming a lawmaker, she was a civil rights lawyer who had won a lot of voting rights cases in lower courts. She had a real reason to care about this case, since many of the closed voting sites were in her district. Justice Stephen Breyer, an 83-year-old with degrees from Stanford, Oxford, and Harvard Law, was a longtime defender of American law. He'd been on the Supreme Court for more than 20 years and was known as a practical moderate with a scholarly style. He asked long theoretical questions during arguments and had written important opinions on affirmative action and the death penalty. Even though he was about to retire, Breyer was still one of the court's most active questioners. Lawyers knew to expect tough theoretical questions from him about how their arguments would affect people in the real world. He wasn't easily impressed and often tested the limits of lawyers' knowledge. Facing Breyer was State Rep. Jasmine Crockett, a new kind of leader. She grew up in a middle-class family in St. Louis, worked her way through Rhodes College, and got her law degree from the University of Houston. Before entering politics, Crockett was a well-known civil rights lawyer in Texas. Her practice focused on voting rights, police misconduct, and criminal justice reform. She won several big cases, including a $4.5 million settlement for a family whose child had been wrongly shot by police. Crockett scared her rivals since she could defend her ideas with excitement and plan things out well. She wasn't just a good speaker, she was a smart legal thinker. She went into each fight with info, past decisions, and knew the rules inside and out. This case would have a huge impact. The Texas rule didn't directly target voters from certain groups. That would have been too obvious. Instead, it made a tricky plan for adding voting places based on past voter turnout, money made in the area, and what the rule called how well things were going. Because of this, lots of voting places in mainly Black and Latino areas closed. At the same time, voting places in rich white areas stayed open or got even bigger. So voters in the affected areas now had to travel up to 20 miles to vote. That's a tough trip for people without a way to get there. What do you think about how the Supreme Court is dealing with voting access cases these days? Do you think they're protecting voters enough? Share your thoughts below. We want to know what you think about this important issue for our country. The atmosphere in the court was intense as Rep. Crockett approached the podium. She wore a simple dark blue suit, her hair pulled back, holding only a thin folder of notes. Her calm way contrasted sharply with the importance of the situation. It was a legislator speaking before the nation's highest court on something that affected many voters. Ms. Crockett, Chief Justice Roberts started, "You're arguing that this Texas law breaks Section 2 of the Voting Rights Act, as well as the 14th and 15th Amendments, but the law never mentions race. It uses the same standards for every voting place in the state. How do you prove there was a biased reason?" "Mr. Chief Justice," Crockett began, her voice strong and clear, "you can show bias by looking at a few things, like what happened in Arlington Heights Heights versus metropolitan housing. This means checking out the history behind the decision, how things played out before the rule was made, if they skipped any normal steps, and just what the rule does. She paused for a sec, then nailed it. We've got proof of all that here. Then she went through how each part of the Arlington Heights case fit with the Texas rule, pointing to stuff in the documents. Judge Thomas leaned in. Representative Crockett, even if we buy your Arlington Heights thing, the state said these closures were all about saving money. Isn't that a legit reason? Judge Thomas, if it really was about cash, you'd think they'd cut polling places all over the place. But no, 93% of the shutdowns were in areas where minorities make up over half the voters. Plus, the state's own number said these cuts would only save 0.3% of the election budget, but mess with 27% of registered voters. She remembered the exact numbers without looking at her notes, and Judge Thomas raised his eyebrows a bit. Next up was Judge Barrett. Okay, say you've shown it's unfair. The Fifth Circuit still thought the state's reason was good enough under the Anderson verdict test. Why should we change that? Judge Barrett, the Fifth Circuit messed up the Anderson verdict test because they didn't look at real evidence of the burden. To do it right, you gotta check what's actually happening. In Crawford versus Marion County, this court said you need to see proof of the burden on voters. She then took a small device out of her bag. With the court's permission, I'd like to show you something. The judges seemed surprised but agreed. This is a GPS tracker that recorded the exact route many voters in affected areas now have to take to get to their new polling place. She turned it on and a small screen showed a winding route. This 17.3-mile trip took our test subject, a 72-year-old voter from Eastern Houston, 3 hours each way by public transport. This isn't just an inconvenience. It's too hard for many working folks and older voters. Judge Alito didn't seem moved. Representative, one story doesn't prove a pattern of unfair burden. I totally agree, Judge Alito, Crockett replied, surprising him with her quick agreement. That's why we did a full transport study for all affected areas, which you can see in Exhibit 47. This study showed that 62% of affected voters would have to spend over 2 hours on public transport to get to their new polling place. For voters with hourly jobs, childcare duties, or physical limits, this is a tough load that the 5th Region totally ignored for almost 40 minutes. The questioning went on at this fast pace. Each judge looked for weaknesses in Crockett's argument, but she answered with details and legal precision that was getting harder to dismiss. Then came the time that would change everything. Judge Breyer, who had been unusually quiet during the questioning, finally spoke up. Representative Crockett, let's think about something. Imagine a state passing a law saying anyone whose ID number ends in an odd number has to vote at location A, while those with even numbers vote at location B. If it turned out that this seemingly fair rule meant 90% of African American voters were assigned to location A, which was much further away, would that violate the Constitution even without proof of obvious racial bias? This was just the kind of complicated hypothetical that often tripped up even experienced Supreme Court lawyers. It meant juggling different legal ideas while keeping the main principles in mind. The judge paused as Crockett thought about the question. For the first time in her argument, she hesitated before answering. Judge Breyer, your idea seems fair on the surface, but it has a very unfair result. Like in Yick-Wovoord Hopkins from 1886. In that case, the court found that a seemingly fair rule applied unfairly violates equal protection. She wasn't done yet. I think your idea really touches on something important in this case. Texas is basically saying that if they use things other than race, then their actions can be illegal, no matter what happens. She then changed direction, unexpectedly. This court dealt with a similar argument in Gilliam v. Lightfoot. There, a 28-sided city limit that excluded 99% of African American voters, but no white voters, was struck down, even though it used location instead of race as the standard. Judge Frankfurter wrote that the Constitution prohibits both obvious and subtle forms of discrimination. Judge Breyer leaned forward, clearly interested. That's right, counselor. But Gilliam involved a boundary so weird that discriminatory intent was pretty obvious. How would you apply that idea to less clear-cut cases? The main thing, Judge Breyer, is checking if the reason Texas gave is fake. In Village of Arlington Heights, this court set out a plan for finding deception by looking at how things happened before the decision in question. She went on without looking at her notes. In our case, we have proof that the state legislature ordered a secret study of voting patterns by race before creating the rules for voting location changes. The study study specifically identified ways to lower voting in minority groups without directly mentioning race. This proof is in emails found during discovery. We're not done with Magistrate Breyer yet. Let's talk more about Gilliam. What specific proof do you have that the seemingly fair standards in the Texas rules, like past involvement and income, are really just about race? This was the moment Crockett was waiting for. Magistrate Breyer, we have the state's own data analysis, she said. She reached into her folder and pulled out a single page. This is a correlation study done by the Texas Division of Territory's own data people before the rule was put in place. It shows a 0.91 correlation factor between their enhancement equation and the percentage of non-white voters in a district. The court murmured, a correlation that strong was pretty damning. And Crockett continued, we have a statement from Dr. James Rogers, the analyst who made the equation, saying that he was told to find seemingly fair factors that would get the desired population result. As Crockett spoke, something interesting was going on. Magistrate Breyer, who was known for being unemotional during arguments, was nodding slightly. The other judges noticed, and the atmosphere in the court shifted. One last question. Representative Magistrate Breyer said, let's say we accept your proof of bias. What exact solution are you seeking? Surely you don't expect this court to oversee the location of every polling place in Texas? No, Magistrate Breyer. We're not asking for that much oversight. We're asking the court to strike down the specific equation used by Texas and require any future closures to get approval from a national district court first to make sure they follow the Voting Rights Act, like the solution this court approved in Shelby County against Holder for areas with a history of bias. Crockett's time was running out, but she had one more thing to say. The right to vote is the guardian of all other rights. When artificial obstacles stop citizens from using that right, our whole democratic system suffers. The evidence shows that Texas's rule makes things hard, and it's not by accident. We're asking this court to do its job and protect rights by getting rid of this rule. When the red light went on, meaning her time was up, Crockett gathered her notes. The room was super quiet. Everyone there knew they'd just seen something special. A really good lesson in defending basic rights. Then came the moment that people would talk about it in law schools for years. Judge Breyer, who usually jumped right into questioning the other lawyer, instead leaned back and looked right at Representative Crockett and cleared his throat. Representative Crockett, Judge Breyer said, his voice filling the quiet room. In my 27 years here, I've never seen a case argued so well and with such a solid grasp of the basics. That statement hit the room like a bomb. Supreme Court justices just didn't give praise like that during arguments. It was a first. Everyone in the room looked back and forth between Judge Breyer and Representative Crockett. The Texas lawyer waiting to speak looked stunned. Reporters scribbled notes like crazy. Law clerks exchanged surprised looks. Crockett, caught off guard for a second by this unusual break from court rules, quickly pulled herself together. Thank you, Your Honor, she started, then stopped. Instead of just soaking up the praise and making it about herself, she did something that showed why she was such a great lawyer. While I appreciate your kind words, what matters is not what I said, but the basic rights of the 1.8 million Texas voters who now face almost impossible challenges to vote. It's their voices, not mine, that deserve this court's attention and protection. Her reply changed what could have just been a personal win into a powerful reminder of what was really at stake. Several judges, including Chief Justice Roberts, nodded almost invisibly. Magistrate Breyer wasn't done. Okay, legislator, I have one more question that gets to the center of this case. The courtroom quieted. You've shown that there's a tie between the area's formula and the ethnicity of the areas it hits. Hard, but a tie isn't proof of cause like my colleagues mentioned. What proof do you have that the Texas government knew about this unfair hit before they passed the rule? Crockett didn't back down. Magistrate Breyer, we have three things that prove the government not only knew about this result, but planned it out. She raised a finger. First, the government record has a statement from Senator Williams, the bill's backer, brushing off worries about how it would affect minority voters. He said, if they really want to vote, they'll find a way. Second finger went up. Second, we have emails between the governor's office and government leaders talking about how many votes against them would be thrown out by the closing formula. These emails plainly calculate the political gain they would get by targeting these exact areas. A third finger, and last, maybe the worst thing, we have a statement from a former government aide who was at private meetings where politicians talked plainly about using standards as stand-ins for race to dodge legal problems. She dropped her hand, taking a whole mad Magistrate Breyer. This makes one thing clear. The Texas government knew exactly what this rule would do, planned the results, and hid what they were doing behind seemingly neutral wording. The Texas lawyer shot to his feet. Your Honor, I have to object to this description of the evidence. None of these statements were found to be true by the Fifth Circuit. Chief Magistrate Roberts frowned. Counselor, this isn't a trial court. There aren't any objections here. You'll have your chance to respond during your argument. The lawyer sat down looking annoyed. It was a telling moment. The state's top appeals attorney had been rattled enough to forget basic Supreme Court procedure. Magistrate Breyer nodded slowly. Thanks, legislator. You can sit down. Jays. Crockett returned to her desk. Justice Kagan leaned over and whispered to Justice Sotomayor, who nodded in agreement. Justice Barrett was reviewing the document, probably checking the correspondence Crockett had mentioned. The Texas lawyer approached the podium, but it was clear that the mood had shifted. Instead of the usual respectful questions, the justices were now sharper and more skeptical. Chief Justice Roberts began. Counsel, let's talk about the correspondence Representative Crockett brought up. Are you questioning the authenticity of these exchanges about the impact of closing polling places? Your Honor, the lawyer replied, those emails discussed political effects, not racial ones. There's nothing wrong with considering political consequences. P. Justice. Kagan jumped in, but isn't it true that in those same emails, the members admit that race and political affiliation are closely tied in the affected area? One email even says that 90% of the impact will be on minority groups, which fits our goals nicely. The lawyer hesitated. Justice Kagan, that statement was taken out of context. I have the full email right here. Justice Kagan responded, grabbing the paper, there's no such context. In fact, the very next sentence is, and I quote, best of all, we can defend this on cost-cutting grounds if challenged. The color drained from the lawyer's face. He clearly hadn't expected the justices to have examined the document so closely. Justice Thomas, usually quiet during arguments, spoke up. Counsel, that's not the point. Under Section 2, it doesn't matter if the state created the existing conditions, but whether the voting system interacts with those conditions to create unequal opportunities. How do you explain that? As the questioning continued, it became obvious that Crockett's presentation had changed the court's focus. Even justices expected to side with the state were now asking tough questions. Justice Breyer delivered the knockout punch. Counsel, let me ask you directly. Do you believe that a law that predictably and demonstrably prevents a significant number of minority residents from voting can be found legal as long as it uses racially neutral language? It was a brilliant question that forced the state's attorney into a hopeless position. The lawyer tried to dance around the issue. Justice Breyer, we believe that a law with a legitimate government purpose applied through neutral standards is legal unless there is clear proof of discriminatory intent. What about the affidavit from the legislative aide describing private meetings where alternative standards for race were openly discussed? How does that fit your standard? That affidavit was deemed unreliable by the Fifth Circuit, Your Honor. Justice Sotomayor challenged, on what grounds was it deemed unreliable? The district court judge who actually heard the testimony found the witness very credible. The Fifth Circuit simply dismissed it as implausible without explanation. When the lawyer's time was up, Chief Justice Roberts turned to Representative Crockett. You have 4 minutes left for rebuttal, Representative. Crockett approached the podium for her final chance to address the court. The entire room hung on her every word. Thank you, Mr. Chief Justice. I will be brief. She took a deep breath. Throughout our country's history, this court has recognized that the right to vote is fundamental because it protects all other rights. When barriers to that right are created, especially barriers that disproportionately affect certain groups, our republic itself is diminished. She looked directly at the justices. The evidence before you shows not just unequal impact, but discriminatory intent hidden behind seemingly neutral standards. The emails, the affidavit, the statistical analysis, they all point to a deliberate attempt to reduce minority voter participation while maintaining plausible deniability. Her voice grew stronger. The question before this court isn't just about our polling places in Texas. It's about whether our Constitution allows sophisticated forms of bias to thrive where obvious ones would fail. She paused, then delivered her final sentences with quiet dignity. The authors of the 14th and 15th Amendments and the Voting Rights Act understood that bias evolves and disguises itself. They entrusted this court with a serious duty to look beyond surface neutrality to protect the fundamental right to vote. Today, we ask you to fulfill that fundamental duty. Thank you. As she walked back to her seat, the court remained completely silent. Even those who disagreed with her position knew their just witnessed an extraordinary legal performance. Chief Justice Roberts adjourned the meeting. The case is submitted. The impact of that Supreme Court argument was immediate and far-reaching. As Representative Crockett descended the courthouse steps, she was greeted by a crowd of supporters, journalists, and legal observers, all eager to discuss what they had just seen. CNN's legal analyst was already reporting live. What we just witnessed may have been the most effective Supreme Court defense in years. Representative Crockett didn't just make arguments. She systematically dismantled the state's position with a command of constitutional law that few experienced Supreme Court advocates could match. Major news outlets ran headlines like "Crockett stuns Supreme Court with brilliant argument" and "Justice Breyer's unprecedented praise signal possible victory for voting rights." Legal experts from across the political spectrum weighed in on the potential consequences of the case. Harvard law professor Lawrence Tribe tweeted, "Representative Crockett's argument today may change how courts assess evidence of discriminatory intent in voting rights cases for generations to come." Even conservative legal scholars acknowledge the power of her presentation. Former Solicitor General Paul Clement commented on a podcast, "Regardless of how one feels about the merits of the case, the quality of advocacy displayed by Representative Crockett was remarkable." 3 weeks after the arguments, Justice Breyer announced that he would retire at the end of the term. In his statement, he emphasized the importance of protecting fundamental principles and expressed confidence in the next generation of legal advocates. When a reporter asked Crockett about the speculation linking his retirement to her argument, she responded with typical humility, "Justice Breyer has served this country with honor for decades. His legacy isn't about any single case or lawyer, but about his unwavering commitment to a constitution that protects the rights of all Americans." 2 months later, the Supreme Court released its decision in Johnson versus Texas Voting Authority. In a surprising 6-3 ruling, with Chief Justice Roberts joining the court's 3 liberals and Justices Barrett and Gorsuch, the court struck down the Texas law. Justice Breyer wrote the majority opinion, which created a new framework for evaluating discriminatory intent in voting rights cases. When facially neutral laws create significantly unequal effects on the voting rights of minority residents, courts must look beyond mere claims of legitimate purpose. Evidence that decision makers were aware of and intended such unequal effects, whether from emails, statistical analyses, or the sequence of events, can prove unlawful discriminatory intent, even absent overtly racial language. The decision went on to quote directly from Crockett's argument. As counsel for the petitioners aptly noted during oral argument, the Constitution forbids sophisticated as well as simple forms of bias. Our prior rulings from Gomillion to Arlington Heights have consistently recognized this principle, which remains essential to protecting fundamental rights in an era of evolving discriminatory tactics. Within days of